Comedian and YouTube star Russell Brand is facing allegations of rape, sexual assault, and abuse from 4 women. The claims emerged from a joint Times and Channel 4 Dispatches investigation into Brand's past conduct. Brand denies all allegations of criminality. The Met Police say they are investigating a number of allegations of sexual assault relating to Russell Brand, but no arrests or charges have been made. And that makes this advisory note issued by the Attorney General, Victoria Prentice, to news editors around the country all the more bizarre. It says this: following the airing of Russell Brand in Plain Sight Dispatches on the 16th of September, there has been extensive reporting about Russell Brand. The Attorney General, Victoria Prentice, wishes to amplify the importance of not publishing any material where there is a risk that it could prejudice any potential criminal investigation or prosecutions. Publishing this material could amount to contempt of court. Editors, publishers, and social media users should take legal advice to ensure they are in a position to fully comply with the obligations to which they are subject under the Common Law and Contempt of Court Act 1981. The Attorney General's office is monitoring the coverage of these allegations. This is a pretty odd intervention from the government. The Contempt of Court Act makes it illegal to publish anything that might prejudice the outcome of active legal proceedings. The logic is that reporting on a live case could undermine a fair trial, as extensive news coverage could influence any jury. But Prentice's statement is strange because a live case has always been defined as meaning that someone has been arrested, charged, or summoned, or that an arrest warrant has been issued, and none of those things have happened in the case of Russell Brand. Writing in the Times, journalist Sean O'Neill gave his view on Prentice's letter, saying this: is the government telling reporters to stop interviewing women who have courageously come forward, stop pursuing legitimate and important public interest journalism? Meanwhile, Brand is free to pontificate on social media channels. Prentice's intervention is a shocking overreach. It is not her job to tell reporters to stop reporting on issues where there is merely the potential for criminal proceedings. It is the job of reporters to uncover misconduct and wrongdoing, to gather evidence that could lead to criminal trials. What will she do next? Curtail all reporting of crime and criminal justice? Or is she only concerned with cases involving celebrities? The freedom to report on crime and policing is under sustained attack. The relentless advance of judge-made privacy law makes it legally perilous to identify suspects who are under investigation or arrest. The Law Commission is proposing to ban reporters from the trials of alleged sex offenders. Secret arrests, secret trials, and now a government threat to curb investigative journalism. So I think that's really well put by Sean O'Neill, right? If you've got an Attorney General saying the mere possibility that something could become a criminal investigation means that you shouldn't report on it, I mean, what can you report on? I mean, obviously, there are certain things one can report. There are sort of policy questions, etc. But so many instances of sort of the newspapers or TV or whoever reporting on abuse by individuals could end up in court, could end up, swaying a jury. But often we only know about these cases of alleged wrongdoing because they've been uncovered by journalists. So the idea that you can't talk about something in case it becomes a criminal investigation or in case someone gets charged or arrested seems incredibly bizarre to me. And, beforehand, it was already somewhat unusual or controversial that we have these contempt of court sort of policing of media. In America, they don't have it. I think there is a good argument to have it. I don't think it's ridiculous to say you shouldn't have wall-to-wall coverage of a case because it will influence a jury, because it may well do. But you should then have a very clear cutoff, right? Yes, you can talk about it until the moment at which a charge is made, and then you stop. If you have to stop talking about it the moment that a charge is possible, that is very authoritarian, right? And it might well be the case that the media can uncover stuff that the police would struggle to do. They have different styles of investigation. Some people are willing to talk to the media and aren't willing to talk to the police for various reasons. As we say on this show, if you have been subject to sexual assault, going to the police isn't necessarily going to be an attractive option because, as we know, charge cases are incredibly low, conviction cases are even lower, and you might end up being under a lot of scrutiny. Obviously, this is not to dissuade anyone from going to the police, but just to say there are many legitimate reasons not to. So to say, this could potentially end up in court, so stop talking about it, just seems bizarre to me. I mean, ill-informed, bizarre, and quite authoritarian. The Attorney General's intervention on Brand isn't the only one that's been coming out of Westminster over the last days. Last week, Chair of the House of Commons Media Committee, Caroline Dinenage, wrote to several platforms hosting Brand's content. This is from the letter she sent to video site Rumble. While we recognise that Rumble is not the creator of the content published by Mr. Brand, we are concerned that he may be able to profit from his content on the platform. We would be grateful if you could confirm whether Mr. Brand is able to monetize his content, including his videos, relating to the serious accusations against him. If so, we would like to know whether Rumble intends to join YouTube in suspending Mr. Brand's ability to earn money on the platform. In response, Rumble wrote back with this: "We regard it as deeply inappropriate and dangerous that the UK Parliament would attempt to control who is allowed to speak on our platform or to earn a living from doing so. Singling out an individual and demanding his ban is even more disturbing, given the absence of any connection between the allegations and his content on Rumble. We don't agree with the behaviour of many Rumble creators, but we refuse to penalise them for actions that have nothing to do with our platform. Although it would be politically and socially easier for Rumble to join a cancel culture mob, doing so would be a violation of our company's values and mission. We emphatically reject the UK Parliament's demands." This to me is strange. And what I would say is going on here is that both sides have got this completely wrong. So you've got a government who seems to be sending out a letter to journalists to say, stop reporting on this case, even if you're reporting factually on this case, because there's an ongoing proceeding, when actually no one's been charged, no one's been arrested. Very unusual to say that. That's not actually the law. So the government representative, the Attorney General, is saying stop reporting on Russell Brand, which to me seems like, a real threat to freedom of speech, let's say. And then you've got the head of a government committee, the head of a parliamentary committee, so not part of the government, but sort of a significant body within the House of Commons, who is saying to social media platforms, or in this case a video platform, please can you make sure this guy is not making any money when he hasn't been, again, charged or arrested or anything like that. And so to me, this just seems both strange, wrong interventions, right? People should be able to report on Russell Brand. People should be able to make harsh judgments about Russell Brand. We certainly have on this show. I think the evidence seems fairly overwhelming. At the same time, he hasn't been tried in a court of law. It seems a bit strange for him to be denied a bunch of services. Now, using a video platform and making money from advertising, that is using a service, right? He's not an employee of Rumble. So to say he must no longer be able to make a living when there hasn't been a prosecution, there hasn't been an internal investigation in Rumble, it's got nothing to do with Rumble. I tweeted about this the other day, the letter from the culture chair of the parliamentary committee to Rumble and to other platforms. And I was saying, the same, I think it's absolutely right for people to make judgments about Russell Brand. People who say you can't make any judgments before this has gone to a criminal court, I think that's ridiculous. I think obviously we can, especially when conviction rates for, when it comes to allegations such as this are so low. I think the idea that, that we shouldn't even be able to judge someone because of that is odd. But the reason I think sort of demonetizing on YouTube or Rumble or anything is a problem is because when it comes to, people keep saying the analogy is like a boss, right? If you're employed by a company, there may well be sort of internal procedures whereby they can terminate your employment if you do something which is problematic but non-criminal. Like that will often be part of someone's contract. My problem with demonetization by Rumble and YouTube, etc., is that if you are employed by someone and they sack you for spurious reasons, right, you can fight them in a tribunal and you might get a massive payout, right? There is some due process there. Like it's not the same standard of proof as going to a court of law where things have to be, beyond reasonable doubt. So there's going to be a different standard of proof. But your employer will have to some degree, say, well, we have done a proper investigation along these lines, and we think this was the reason that you needed to lose your employment, and you can take them to an employment tribunal, and there will be, it won't be justice in the sense of, a court of law, but there will be some sort of due process. When it comes to YouTube or Rumble, because they're not employing you, they're just providing you a service, they can cut you off without any proceedings. And I think that is giving them more power than an employer, essentially, because your income is reliant on them, and they can just say, oh, we don't want to use you anymore because it looks bad to our advertisers. And what that does is it just gives them enormous power, and it also gives advertisers enormous power because they can say, oh, we don't like this guy. Can you ruin their career? Can you make sure they can't make any income from this? Russell Brand, of course, will be fine because he's a very, very wealthy man. But the precedent here, I think, is very problematic and one that shouldn't be taken particularly lightly. I mean, I'm sure you can say actually the same thing about, obviously, cancel culture and reputational risk is less involved when it comes to an Uber driver or a Deliveroo rider. But you've got a similar situation whereby someone can be fired without any of the due process that you get via a employment tribunal. And so the idea that, well, they're a private company, they can make their own decision, I think is very problematic and one which should be resisted.